Hello, everyone. I hope you are all out there in remote digital land and appreciate your joining us for this conversation today. My name is Joey Chen. I'm a television news anchor and journalist in Washington, D.C. And this is a subject that is particularly of interest to me, but really to all of us at this point. This is one of the hot button issues of our time. And indeed, the Supreme Court has taken on some very challenging ones at this point. But this one is a real hot button issue right now because the subject of the case that we're talking about today, which is known as Trump v. Barbara, goes to the very, very essence of who we are. In fact, this case takes up the question of birthright citizenship, or for those of us who are lay people, really defines who can say, I am an American. Consider that. We're going to hear from some of the best legal minds on this particular issue today, and in particular, how the experience of Japanese immigrants who were held in confinement during World War II and their children might really be key and pivotal to the Supreme Court's decision in this case. Now, take a look at the chat space at the bottom of your screen. You will see the bios of our guests today. They will include Professor Eric Muller from UNC Chapel Hill. His insight and expertise on the subject of the Japanese internment camp experience has already been identified by the High Court as a really key argument in this case. Also with us today is Larry Oda, who many of us know as a leader in the Japanese American community, a longtime leader in JACL. He represents in this particular conversation the lived experience of a child who was literally born into the center of this debate. Also with us today are Rachel Grossman and John Nakahata of the HWG law firm. Now, they have worked very closely with Professor Muller on the amicus brief in the case about how the internment experience connects to Trump v. Barbara. I want to note that there are several organizations which join together to coordinate and sponsor today's conversation for us, recognizing what an important role AAPIs play in this discussion. They are, first, the National Japanese American Memorial Foundation, which this year is marking the 25th anniversary of the JA Memorial to Patriotism in World War II. Also, we receive support from the JACL, the Japanese American Citizens League, which is the nation's oldest AAPI civil rights organization, and our friends from APIA Vote, which is the nonpartisan nonprofit devoted to strengthening and sustaining civic engagement throughout the AAPI community. Also, the Heart Mountain Foundation, which preserves the confinement site in Wyoming, Heart Mountain, and which continues to highlight the lessons learned from the Japanese American confinement experience and the relevance to all of us today, which indeed this discussion really focuses on. Our thanks to all for the support there. So let's get into it. I'd like to start with John to help us get sort of the broad outlines and lay of the land, particularly around the executive order from which Trump v. Barbara emerges. And John, I think like most of us, I understood the principle of birthright citizenship to be settled. It just is the way it is. And I want to give you an example of how deep that agreement and knowledge is. The story that really stood out to me of a Japanese student who came to Indiana University to study. And as her visa was about to run out, she appeared before the immigration officers, and she remarkably ran into an immigration officer who said, "I'm sympathetic to you," remarkably. And she then said, "Well, is there any way I can stay? Is there any way I can stay longer?" And this immigration officer looked at her and said, "That guy who brought you in today, is that your boyfriend?" She's, "Yes, it is." And he told her, "If you'd ever thought about getting pregnant, now would be a good time." It was a striking statement. It's also a story that I tell because it explains not only why I'm a TV anchor, but I was also from birth an anchor baby. It is the story of my parents and how I came to be a birthright citizen of the United States. But I also tell this story because I think it confirms really that this principle of birthright citizenship has long been understood, accepted legal principle. I mean, an immigration officer actually told my mother, go get pregnant, have a baby. That baby will be a citizen. You'll be able to stay with her. But President Trump, of course, in his very first executive order of his second term, challenged that vision. And John, if you could just give us sort of the 30,000-foot view on what does the executive order say and what does it mean?
That's your story is a great lead-in, Joey, to what the executive order actually said, because it sort of directly addressed your mother's situation. The executive order, and the president clearly was trying to limit who could be deemed to be an American citizen. The executive order said that a child born to a mother who was either unlawfully in the United States or here lawfully but on a temporary status, and whose father was not a U.S. citizen or a lawful permanent resident, um, would not be allowed to stay. Now, I guess your father might have been a U.S. citizen, but maybe not. But if he wasn't, then you would have been not a U.S. citizen by birth under the executive order.
So this directly would have applied to me.
Yeah, if your father was not a U.S. citizen or lawful permanent resident, because on a student visa, for example, or on temporary asylum or other temporary assignment, or undocumented. I mean, any of those statuses would not have qualified you for birthright citizenship under the executive order.
So
So
John,
that's
explain
that.
to
Go
I
ahead.
mean, I thought that the 14th Amendment did this, right? Like, isn't it laid out in the 14th Amendment that you're born here, um, you get citizenship? Isn't that the way the 14th Amendment reads?
That's certainly the way that I think all of us, and certainly I would have thought of it. Um, the administration looked at the 14th Amendment, and the 14th Amendment specifically says, it doesn't say all persons, it says all persons born or naturalized in the United States and subject to the jurisdiction thereof. Critical phrase, and subject to the jurisdiction thereof are citizens of the United States and the state where they reside. So the fight in essence is over what is the meaning of and subject to the jurisdiction thereof.
Okay.
So
The jurisdiction thereof in legalese.
in legally it's literally about in legalese, what does that actually mean? Does that mean you are present in the United States and you have to obey the laws of the United States? That's one version of jurisdiction, sometimes called local jurisdiction, could be called temporary jurisdiction. A different definition, the one the administration put forward, was to say it means you have some kind of permanent allegiance to the United States. Um, Never really fully defined, frankly, by the government. They said they quickly kind of pivoted to say it meant domicile, which is another fancy legal term, which also is a lot of different meanings. So it's not like a word that has just a single accepted meaning.
Yeah.
But they
I
said,
mean, domicile to me just means you live there, right? I mean,
yeah, it's generally accepted to be the place that you live and intend to return to.
that you
Um,
think of as your home. I
your
mean,
home,
it's
or if
not
you're a
just
snowbird, it's like you're permanent. You're one that goes back to as opposed to the one that you go to visit, 3 months out of the year or something like that.
okay, but on that point, I mean, there have been other both cases and practices. I think most of us know the story of Wong Kim Ark, that this is a guy born in San Francisco, went to visit relatives in China, couldn't get back into the country. I mean, this wouldn't this apply? I mean, this is the standard that was set all the way back in Wong Kim Ark's day.
So this was one of the central arguments in the case, actually. which is in Wong Kim Ark's case, the court, in reciting the facts of the case, several times referred to Wong Kim Ark's parents as being having domiciled in the United States. It's not entirely clear when you read the decision what the court actually meant by that, because sometimes they talk about commercial domicile, sometimes they just use the word domicile. But that is the point that the government kind of latched onto to justify their argument. And they said domicile means something more robust than just somebody who is present in the United States. So that was the administration argument, and the argument of the ACLU and others who were challenging the administration was no, it just means are you in the United States and are you somebody who so you had a duty to follow the laws of the United States.
And
And there are a
not,
couple of noted exceptions to the subject to the jurisdiction of thereof had a couple of very well recognized exceptions for ministers like foreign diplomats, and people who were, if you were, foreign troops occupying a part of the country or something like that. And
very
Native
specific.
Americans, very
Oh,
Native Americans because of the unique history of Native Americans. But those very, very specific and narrow uh, exceptions were those people were viewed as not subject to the jurisdiction of the United States.
okay, but there are also other things. Not to get too far into the weeds on this, and we might have to return to it again later, but there were the Immigration and Naturalization Acts that also seemed to confirm what we generally understood about birthrights. Isn't that correct?
That is absolutely correct. The Immigration Acts, both in 1940 and 1952, they used the same language of the 14th Amendment that is embodied in the 14th Amendment. Um, but they provide a different avenue for thinking about the issue because one of the government's arguments was, well, people's understanding of what the 14th Amendment meant changed from its origin to until the 1940s. And so that you should only apply the statutes according to the pre-1940s understanding of the 14th Amendment, which the ACLU and others they disagreed with that understanding. So, but this is in the government's view. Only apply it with respect to the pre-1940s understanding. But if you look at the 1940s understanding, and that's a large part of what our brief was about, then it would seem to have a different result. So.
Okay, we may circle back on that point a little bit later, but I just want to emphasize here that we have now come to the same understanding that that immigration officer presented to my mother, that more or less you're born here, you belong here, you're one of us, right? There is another part of Japanese American history that did get the court's attention, and it was raised by Professor Eric Muller, who joins us as well. Professor, really appreciate this. I know you teach a whole course on sort of the legal and ethical issues that come out of Heart Mountain and the Japanese American internment experience generally. But when it came to this particular case, Trump v. Barbara, you offered an amicus, a friend of the court brief. And in it, you point to three groups of people who were confined and, more importantly, their children. Who were they and how are they related to this case?
Yeah, thanks, Joey. Thank you so much for hosting this, by the way, for moderating this. We really do appreciate it. I was able to tap into my knowledge that comes from studying the this period of history since the late 1990s. When you really dig deeply into this history, you learn that below the surface of the history that's kind of taught, if it's taught, in a high school class or a college class, some people may be familiar with the very famous Korematsu versus United States case, which is a Supreme Court case from the 1940s. That if you dig beneath that, you learn that the story of Japanese American incarceration is not one story at all. It's Frankly, it's 120,000 stories. There are as many stories as there were individuals who were illegally and unjustly incarcerated by the United States. But when I read the government's brief in this case and saw that, as John so helpfully summarized for us, saw that the government was trying to kind of come up with a new way of understanding the limitations on birthright citizenship. This idea that the parents have to have allegiance to the United States and to be domiciled in the United States. Little bells went off because I knew right away that there were stories of Japanese Americans that flew directly in the face of that. That is to say, parents who, as at least as a legal matter, did not have domicile in the United States, did not hold allegiance to the United States in any conventional way, who had babies behind barbed wire, and those babies were recognized from the get-go as U.S. citizens. So that's the existence of these groups of these sort of little sub-histories, these subcategories of Japanese Americans really tend to refute the government's theory of what the 14th Amendment and these statutes mean. So I'll just briefly tell you who the three groups were. The first group were babies born to people who had the designation of enemy alien. That is to say, people who immigrated from Japan, who were in the United States at Pearl Harbor, who could never have become citizens because Japanese immigrants were not allowed to become citizens at that time. So once we went to war with Japan, there was a statute that kicked in that took all of those resident aliens, all of those immigrants, and gave them the legal designation of enemy aliens. That made them subject to arrest, to deportation, lots of things. And in fact, the government did sweep through and arrest thousands of Japanese immigrants and place them into Justice Department internment camps. Their
So they went to
families
Tule Lake and they went to Hart Mountain and they went.
well, so these are actually, no, this is, yes, I'll get to those in a minute, but this is a different kind of arrest. This is just under the authority of the so-called Alien Enemies Act. So these are people who were rounded up often right after Pearl Harbor, within days, and who were placed in Justice Department internment. When they had babies in an internment camp like the Crystal City camp in Texas, those babies were recognized as U.S. citizens, even though the parents were enemy aliens who did not have allegiance to the United States and who had been ripped from their domiciles and placed behind barbed wire, perhaps to be deported to Japan. So that's the first category, babies born to enemy aliens. The second category was a very interesting group who were at Tule Lake, one of the 10 camps run by the War Relocation Authority. So these were people who were American citizens. They had been born in the United States. So these are the second generation, the so-called Nisei generation. A subset of them grew so disgusted and angered by the abuse of the injustice of their treatment that they reached a kind of boiling point partway through this period and decided to renounce their U.S. citizenship. Congress passed a law to allow them to do exactly that. And so when these people at Tule Lake filed these renunciations, they filed something that said, I hereby attest that I am giving up all allegiance to the United States. It says allegiance in the document. They had babies, these so-called renunciants, the renunciants of citizenship, they had babies. Those babies were recognized as U.S. citizens from the get-go. So that's category two.
Well,
And then
just a moment here. These are also sort of the no-no boys that were many of us that
there's a
were.
lot of overlap with, yes, there's a lot of
Okay.
overlap with that so-called no-no group, correct. And then the third category is the one that in many ways I think is the most interesting and kind of shocking. So when people emigrated from Japan in the late 19th and early 20th centuries, they didn't just come to the United States. They came to countries all through the Americas, including countries in smaller numbers in Central America and South America. A sizable number of Japanese immigrants from Japan went to Peru. And they stayed there, they established themselves there, just like Japanese Americans in the United States were doing, but these were Japanese Peruvians. Um, they became as unpopular and disliked in Peru by Peruvian society as Japanese immigrants to the United States became because of racism here in the United States. So when World War II started, Peru saw an opportunity to sort of get rid of their Japanese, ethnically Japanese population. And in the meantime, they had a good dance partner because the United States wanted ethnically Japanese bodies that they could put on ships and send to Japan for prisoner exchanges. So it's hard to believe this is true, but basically, Japanese Peruvians were rounded up in Lima and wherever else they were, thrown onto ships, shipped up to the United States, and placed into the Crystal City internment camp, which I mentioned before, this Justice Department run internment camp, being held there solely for the purpose of being bargaining chips to trade to Japan for Americans trapped in Japan when the war started. These Japanese Peruvian internees had babies at Crystal City. Their babies were recognized from the get-go as being US citizens. And it's really important to note this last group because literally these are people, it's not just that they had no allegiance to the United States and no domicile in the United States, they had no connection to the United States of
They were
any
hostages.
kind. They were hostages. They were brought against their will to the United States and placed in a concentration camp. Their children were US citizens. So, just to wrap this little history lesson up, if the government's theory were true that a parent needs allegiance to the United States and needs domicile in the United States in order to give birth to a birthright citizen, none of those children would have been US citizens. And yet, very, very clearly, there's clear documentary evidence that they were treated as US citizens from the get-go. So that's the contribution historically that I was able to bring to the table with the assistance, of course, of Rachel and John at the law firm to show and to provide evidence that these clear categories of babies were recognized as US citizens, which is very powerful evidence, at least, that in the statute from 1940 and the one from 1952, that those statutes, which were enacted right around the time of World War II, that these babies kind of disproved the government's theory of the statute. And it's also like you would think if allegiance was key to citizenship under the 14th Amendment, like when was allegiance more in question than during World War II? You would think that if the government's theory were right, it would have materialized during this crisis of allegiance, but we never heard a word about that during World War II. The government never took the position during World War II that it's taking today. So those are the cases that I was able to, from my years of archival research, I was able to bring to the court's attention.
Yeah, I just want to be clear that I understand this fully. I mean, what you're saying is in these internment camps, there are three groups of people who had babies. These these parents didn't have allegiance to the United States, were willing to say, I may have had allegiance, but I am renouncing anything having to do with it. I'm not playing at all. If you want to call me an enemy combatant, you call me that. But whatever it is you're going to call me, I am giving up any of those rights. And people who were, in fact, kidnapped from what they considered their home country, brought here against their will, without charge, with just here you are, here's your bargaining chip, here you go, put them in
Yep.
there. All these people, and in every case, the US government, its immigration authority, did not regard these babies as anything but US citizens.
That's right, Joey. And I'll make one quick point before we move on to the next segment. And that is that the reason these stories are so important is that they're a subset. So Fred Korematsu, just to take one example, was born in the United States. He was born to lawful resident alien parents. So Fred Korematsu and the rest of the Nisei, the first generation born in this country, the government's theory in this case would not alter their citizenship because their parents were their immigrant parents were domiciled in the United States and they had this kind of legal allegiance to the United States. What's different about these little subcategories that we rely on in our brief is that they were different from all of the other Nisei generation. They were born not to lawful resident aliens, but to these categories of enemy aliens, renunciants, and Japanese Peruvians. And therefore, these are the people whose citizenship the government's account would say shouldn't exist, but it does. And so that's really the thrust of the brief.
Hmm. You talk about the personal stories in this and also the government's recognition of individual babies as U.S. citizens. And in fact, you have a clip that really demonstrates what the U.S. government thought of these babies. Can you tell us about that?
So the the thing that this brief does, so an amicus curiae brief, a friend of the court brief, is different in nature from a brief that's filed by one of the actual litigants in the case, the actual parties. What amicus briefs are supposed to do is they're supposed to chime in sort of from the side and show the court distinctive things or take distinctive views that the parties to the case themselves aren't presenting or can't present. And we'll talk more about this, I think, later. But one of the reasons that I think this brief sort of rose a little bit out of the others and drew attention is precisely because the core of the brief are these three human stories. I found three individuals, one of whom we're about to meet, three individuals whose own personal human narratives, not just of their births behind barbed wire, but their subsequent lives as loyal U.S. citizens who joined the military and who became government scientists and who, became high school football stars. These human narratives, I think, are something that the parties themselves, it wouldn't have been appropriate for them to include that kind of narrative approach, the human story, the human drama, if you will. It wouldn't have been appropriate, but that's something that we could do as an amicus. And I think that that's, I don't have a crystal ball, but I tend to think that it may have been the drama, in a way, of the individual human stories that are told in the brief that caused it to kind of emerge from the pack and draw some attention.
And the pack was to make the point here, in case people not been following this closely, the pack was considerable. There are some 70 of these amicus briefs that were filed, 70 different participants who are, in a way, non-combatants in the actual case, but who offer their insight into particular areas of argument. Of these 70, one of them rises to the attention of Justice Ketanji Brown Jackson, who actually specifically mentions it during the session. Also, the ACLU lawyers comes forth on it. This really did get attention, the human story element of it. And in fact, the way the government depicts these babies in their propaganda.
Yes, that's right. And I think that we might even be able to show our audience a little glimpse of what that propaganda was in the form of a short clip from a propaganda film that the Immigration and Naturalization Service made about Crystal City. They brought cameras right into the camp to try to make the camps look like nice places. And as I think we can see in a moment, they kind of made the point themselves pretty clearly about the citizenship of these babies. Can we cue that up?
Young America. About 250 Americans were born in this hospital.
These were children clearly identified as babies born at Crystal City, and they were regarded, as it says in the film, as young Americans. Even the
Precisely.
government identified them as young Americans. And one
Exactly.
of them, as you say, is with us now, Larry Oda. Larry, so many of the folks in our audience do recognize you for all the work that you have done for
Wow.
Japanese Americans, for the AAPI community generally, and in your leadership of JACL. And you are also one of the named stories in Professor Muller's and Rachel and John's brief. You are the story at the heart of it. Um, can
Thank
you
you.
can you just give us an idea what it means to you to see this sort of depiction of you and all those other babies who were born into the middle of this argument?
Uh, I'm honored to be here with you to take part in this. Uh, I was uh, born toward the end of the existence of the Crystal City Justice Department internment camp uh, existence. So when I hear the narrator talk about 250 babies that were born there, and so that was they were showing probably in that clip, uh, the ones that were born later in the existence, and I'm probably in there. Um,
You were the cute
I
one that we saw there,
yeah,
right?
well, yeah, well, I don't know. My head was too big, I think, but maybe you recognize me. I don't know. But uh, I think that I'm just so honored to be here. I was uh, had talked to the JACL had another brief. We're involved in I think three suits, and the John or Eric mentioned the Enemy Alien Act, and JACL has filed an amicus to uh, fight the Enemy Alien Act. And my story, because my father was uh, identified and arrested under that act and put into Crystal City, Texas, that um, I'm, yeah, uh, Eric was aware of that, and because of that, and since I was born there, I'm one of the yeah, birthright citizens, and he talked about the assumption was that I was an American citizen. Uh, I grew up uh, thinking nothing of my citizenship. I went to school. Um,
You are, I mean, by any stretch of the imagination, I don't think anybody can argue that Larry Oda is anything but an American patriot. You are a true blue kid from Monterey,
Thank you. Yeah, right.
he served in the U.S. Navy in intelligence. And
Right.
there is nothing about you that is anything less than a loyal patriot. But I
Yeah,
wonder when you hear this sort of argument made by the administration that somehow people like you who established their citizenship only by birthright shouldn't be considered citizens at all. Uh, What does that mean
right.
to you?
It really means that s someone's making the wrong interpretation. I think you know, I lived my life as an American citizen. I served my country. I served my community. But for someone to say that, yeah, I need to back up. My mother was born in Watsonville, California. So she was a birthright citizen. Um, because of the laws at that time, when she married a Japanese national, she lost her citizenship. So when I was born, neither of my parents were American citizens. My dad lived in the United States for 25 years prior to his being incarcerated. So there's a lot of ifs, ands, or buts, and I think that uh, maybe that's not the point. The point is that I feel like I'm being targeted for being a birthright citizen. You know, I that citizenship could be taken away. It may not be. I think that the actual wording of the Trump's executive order is targeted more at recent immigrants. And I'm thinking that this is just conjecture that the he originally targeted Venezuelans, and then here we're targeting the Venezuelan drug runners and deposing the Venezuelan president to take control of their oil. Anyway, that's it. Yes, I'm getting off
Well,
topic.
but to your point, though, I mean, you talk about targeting, and I think that, a lot of us, yeah, okay, we maybe understand what the government is getting at or what the president
Mhm.
is getting at, but surely they don't mean me. Surely I am not a target. Surely people understand that I am a true American. Would you have a warning, though, that, thinking about your mother's experience and thinking about this executive order, that we can't just assume that
No,
that's
we
all.
really can't assume. I look at it as if they can do it to someone else, they can do it to me. And we need to stand up for everybody, not just for me, but everyone. Whenever we uh, see someone else being targeted, we need to stand up and say something. So, and that's what you know, I feel that we're trying to do now with this.
Mhm. To remind people of that.
Right.
Thanks, Larry.
Okay. Thank
I know
you.
you're going to have more questions here. I know we're going to see more questions for you in our Q&A section in a little bit, but I want to bring in Rachel here and John as well, coming back to us. John, I know that you too have family history with the camps, but Rachel, you first, as the professor noted, it's those personal stories and the stories we hear from Larry that really make a difference here. How do you connect something like that to here's the legal argument, justices? How do you pull those things together?
Yeah, well, that was our real goal. When Eric came to us with these histories, they have a real intuitive, powerful, sort of human appeal. And our job was not to fix that, right? That already existed. Our job was to pair that really intuitive storytelling human element with the legal framework that helps the justices understand why these compelling stories fit into the legal questions that are being presented in the Trump v. Barbara case. And so what we did is we looked at the history, we read through the briefing that was already existing in the Supreme Court case, and we saw that the link here is really with the 1940 and 1952 statutes. What the events that Professor Muller highlighted and that Larry exemplifies occur in this really important period right between after the original immigration law was passed in 1940, but before Congress reenacted an immigration law, our current immigration law, in 1952. What that tells us is that Congress was actively thinking about immigration and about citizenship status during this really important pivotal period in American history. and had the opportunity to think about these questions, as Professor Muller pointed out, in this really important period in World War II when allegiance is central to the way that Americans are thinking about their place in the world and their safety and their relationships with one another. So we paired these individual stories, the history, the documented examples, with that statutory framework to point out that Congress passed this law in 1940. It uses the exact same language in relevant part as the 14th Amendment. So it says people who are born in the United States and subject to the jurisdiction thereto are United States citizens, mirrors the language of the 14th Amendment. After that statute was passed, they're conferring citizenship on people like Larry without blinking an eye. And then in 1952, just a few years after World War II is wrapped up, Congress revisits the question of who should be a United States citizen, and they didn't change a word of the statute, not in relevant part. They repassed the statute that says exactly the same thing. People born in the United States, subject to the jurisdiction thereto, are United States citizens. So we use the historical examples to make a statutory argument that says, Congress is aware of the way that its laws are being interpreted. It had this perfect opportunity to clarify if it meant something different by.
It had multiple opportunities
It
to
had
do.
lots of opportunities, and this was one opportunity to clarify that if it meant something other than if you're born in the United States, you are a citizen of the United States. And it didn't take that opportunity. And what you can infer from that is that that's exactly what the statute means. It means exactly what we all think it means. It confers territorial birthright citizenship. So that legal framework puts the really intuitive human stories into the sort of analytical, brainy framework that lawyers are used to thinking about, and that the justices have to, decide cases within that framework. And it helps them understand why the stories that feel so important to us, in fact, are legally significant. And it gives them an opportunity to decide the case in, our favor and in favor.
But also in an interesting way, and again, not a legal scholar here, but reading what you have written about this, I am struck by this. I mean, we look to the Supreme Court to make decisions based on the Constitution, right? We're thinking, oh, well, the justices are deciding, does this meet the terms of this amendment or this part of the Constitution? We always think of the Supreme Court as an arbiter of the constitutionality of a decision. And yet, what you're posing here is a possibility that maybe they don't have to decide based on the 14th Amendment at all.
Yes. So there's a legal principle that any lawyers on the line will probably be familiar with called constitutional avoidance. And it is a theory that if you don't have to interpret the Constitution, you shouldn't. You should just avoid the question. And the reason for that is that it's really hard to change the Constitution in the United States. We have to get Congress to approve an amendment, and then it has to go to all the people, and then we vote on it, which is why our Constitution is relatively stable in the canon of American law. What is much easier to change is a congressionally passed statute. All that has to happen is that Congress has to decide to change the law. Just like it decided not to change the law in 1952 when it was last visiting some of these immigration and citizenship questions. So what this does is it gives the justices of the Supreme Court an opportunity to decide the case in a way that, frankly, is a little bit less politically risky than having to decide the constitutional question. If you decide what the 14th Amendment means, it means that for all time, unless the Supreme Court changes its mind later, but we'll put that off for a different discussion. But if you interpret what a statute means, the American people at the very next election can elect people into Congress and say, that's not what we wanted this to mean. You can change the law again. So it's an
It's
interesting sort
sort
of
of giving the justices sort of a way out, right? I mean,
I wouldn't consider this a way out. I think this is exactly how American law is set up to work, with a balance of powers between three co-equal branches. So here we have an example of the president passing an executive order, putting into law an executive order and saying, this is how I want the law to work. The court takes up the question that was presented by people who are going to be impacted by that executive order, and it has two different ways to decide the question. It can put a period, close the book, and interpret it as a constitutional matter, or it can take the statutory interpretation route and say, this is how the statutes currently work. What that does is then gives the statute makers, that's Congress, an opportunity to then clarify the law if that's what they want to do. I think that some of my colleagues would agree that the 14th Amendment also works the way that we've been talking about it on this call. But what this is an opportunity to take a sort of narrower decision point. And it also just really ties in really nicely with the historical examples that Professor Muller brought to our attention. So we paired up, again, those human stories with this statutory framework, both because it's the most compelling legal argument that we could make. It's hard to talk about the meaning of a 19th century constitutional amendment with 20th century examples. So partially it fits with our facts. But it's also a legal strategy where we can offer a route that might make it easier to decide this case in favor of the respondents here.
And so let me jump in here, Joey. This actually came up at the end towards the end of the argument. Justice Kavanaugh actually asked Cecilia Wang, who was arguing for the ACLU, couldn't we just decide this as a statutory matter? You know, if you win on the statute, would that be fine? And she essentially said, "I'll take a win." Whichever way it comes. So it was clearly that at least for Justice Kavanaugh, I mean, Justice Jackson is the one who raised Professor Muller's brief directly, but Justice Kavanaugh was clearly sort of looking at the statute as one way to resolve the case. And of course, Congress doesn't have complete free reign if there's, in enacting a statute. I mean, if they were to enact the Trump executive order, the next question would be, does that correspond with does that meet the terms of the 14th Amendment? One big difference with a statute, and this goes a little bit to what Larry was just saying, a statute, if you pass a statutory change, it's necessarily prospective. You can't enact a statute retrospectively. Which is what Trump's executive order also tries to do, is act prospectively only. But if you're interpreting the Constitution from 1868, there's no limiting principle that says it only applies going forward. So Joey, you and Larry could be subject to a later administration saying, you know what, that interpretation goes backwards as well as forwards.
Yeah,
And that was something that also came up at the oral argument.
so Larry and I really could be in trouble if that were the case. But looking at this, and I want to encourage people to drop questions in. I see we're already getting a number of questions, but I have 100 other questions I want to ask about this. But would you give an over/under on how the court is going to go on this, John?
So on the result, I think the good guys are going to win. I think I don't think the court is in a result going to overturn the essential existing understanding of birthright citizenship. I think the harder question to anticipate is whether that they do that on a statutory basis or on a constitutional basis. I think there will clearly be at least some that say, I would decide this, even if it goes on a statutory basis, I would say I would also decide this on a constitutional basis. But as a matter of cobbling together a strong majority, which if Chief Justice Roberts is writing this, he may want to get as many people together on an opinion as possible. Um, the statutory angle, the statutory approach may be particularly attractive because it may get some people to join who might not otherwise want to join.
Yes. I want to get to these questions because I think that they they have resonance and clearly people are concerned and interested in this. Um, Bob Sacanella is asking, did the Japanese Peruvian hostages have any immigration status in the United States? Were they considered undocumented? And this also raises to me, if if people were to lose their birthright citizenship, wouldn't we be creating a whole class of stateless individuals? And people like me, right? Like if I were to lose my birthright citizenship, then by definition, I would be stateless, wouldn't I?
Yeah, I mean, if as John was saying, if the constitutional decision were understood to apply retroactively and at least permit a future government to do this, then yes, if you were denaturalized as a U.S. citizen, or not even denaturalized, if you were simply stripped of your birthright citizenship, then you would be stateless. And to Bob Sakaniwa's question, it's a rich irony that the United States government, who snatches people off the streets of Lima, brings them to the United States, puts them at Crystal City, actually gives them the designation of being illegal entrants. They were placed in a class of people who had entered the country illegally. Now try to figure that one out. They didn't want to enter the country at all,
Undocumented hostages.
right? So that yeah.
Yeah, it's the most fascinating story, that of the Peruvian Japanese, to me. I just found it such an interesting story that really doesn't get told enough in the
Yeah.
major media. Ford and Mari Fuji asking, based on the comments of the Justice Department, so to that point, what's your opinion on how they will rule? We heard a little bit from John on that. Rachel, Professor, do you have any other thoughts about where this goes?
I'm not a betting woman, and betting on the Supreme Court is a notoriously fraught exercise. So I'm going to go with what John said, and
I very much agree with John in his predictive in his crystal ball. I think he's seeing clearly. I did just want to sort of drop the comment though that I think for many people, if the court ends up ruling on that ground, I think that people will be happy that they ruled on the basis of the statute and that birthright citizenship is sustained. I also think it'll be tinged with some disappointment though. Because the Constitution is our founding document, right? I mean, it is what makes us us. And to shy away from making a statement about the DNA of the United States in the United States' organic document would be a little bit disappointing. I mean, I think it would feel to some who are otherwise happy with the outcome, it still will feel, I think, like a little bit of a letdown. Like the court wasn't able to kind of muster the ability to speak clearly about what it is that makes an American an American. Still, we'll take the win. At the end of the day, we'll take the win.
Yeah,
But
let me just add to what Eric just said, because, and one reason for the disappointment, right, personal disappointment if they go down that road, is we will, and since I live in Washington and practice in Washington, we will be looking at 20 years of legislative attempts to enact the executive order. It'll become a central feature of fundraising for certain people. And so we'll have 20 years of, until people give up or they actually pass it, and then the case goes to the actual case goes to the Supreme Court again, which would be very unfortunate for the reasons that Eric has pointed out. I mean, it would be nice to have this sort of idea that people that are born in the United States which has been sort of, it's part of our DNA. I mean, across all communities, there's a long history in the Asian community. There's plenty of history in the Irish community, other European communities of people's ancestors who came here not not within the quotas that were set up from 1924 to the 1960s, right? Who had kids, and these kids were all U.S. citizens, right?
Yeah, I want to go to Kath Masaoka on this. How do you prevent these kinds of politically motivated, racially targeted executive orders? Hey, I'm a journalist. I'm just reading the question. I'm not making a statement about that from happening in the future. We cannot depend on the right people being elected. That changes with each election. You know, I guess this goes to the point too that you're making, that even if the court clearly rules against the executive order, it doesn't seem like that's going to be the last word. I mean, the president has been talking about ending birthright citizenship since his first term. I don't imagine that he or his lawyers would be willing to just drop it.
Well, that's the power of the constitutional argument, Joey. And I think it's the reason that, we took this particular approach because it fit the history that Professor Muller had raised to our attention, and that really gripped people. But the reason that, the ACLU is advocating for a constitutional decision is because that would sort of put an end to it. You can't pass an executive order that violates the Constitution. You can't pass a statute that violates the Constitution. So if you can get a decision from the Supreme Court that says this is what the 14th Amendment means, that's the end of the story. Now, it doesn't go directly to the question, right, which is how do we prevent hate in our elected leaders? And I wish I had an answer to that other than that we build community and we try to do better at electing people that we trust and that have values that I believe in as an American. But at least as far as this executive order, a constitutional decision from the Supreme Court would put the issue to bed.
Asking for William Schwartz, can you discuss how birthright citizenship is one of those fundamentally American ideas that make our nation different from other countries? In fact, birthright citizenship isn't guaranteed in all countries, and really only a fraction.
That's correct. That was actually at the core, one of the things that came up at the core of the arguments here. There are basically two different ways that countries handle citizenship. Probably more common is by descent from the parents. I'm not going to try to pronounce the Latin.
We can't even get
this.
amicus right, so
Right. But there's, a lot of countries, the child is deemed to inherit the citizenship of the parent. That is not the way that the English common law grew up, and it's not the way the U.S. grew up. And so the other way to do it is where you were born, and that's the way the 14th Amendment is clearly written. It's clearly written around a theory of where you were born, not descent through the parents.
Let me just throw in that there was another amicus brief that was filed by the man who taught me federal courts years and years and years ago back in law school, a professor at Yale named Akhil Amar, who makes the argument very clearly that if the 14th Amendment had not been intended to enact birthright citizenship like we understand it, and had instead been based on this weird dance about who the parents were, you would have expected the word parent to appear there. You would have expected something about parents to, rather than saying any person born in the United States is a citizen thereof, you would expect the language to key into the factors that the government is now saying it did, but it didn't do that. And he makes the further, I think, very nice point that this would open up a massive can of worms. Which parent? Is it the does the 14th Amendment require both parents to have the allegiance and domicile? Is it just the mother, just the father? What do we do if we don't know who the father is? Like you can imagine just countless weird scenarios, not weird, but countless detailed scenarios that all of a sudden we're going to have to be developing constitutional law to figure out what to do in a situation where you know who the mother is but not the father. So while it's true that birthright citizenship, like we do it, is a minority kind of position among the world's nations, um, I think that our founding document is actually pretty clear about that. You might want to call it idiosyncrasy.
And isn't it the
And,
nature of America of the United States to think in this way, to be embracing of people from the world?
I don't, I
certainly,
think on the base of the Statue of Liberty, I don't think it says, "Give me your domicile, you know, your your two-parent family." It's "Give me your poor, your tired," right? So yes, I think that's correct.
yeah, and this actually came up in the argument again in front of the court. And interestingly, and part of what makes me more optimistic about where this comes out is it was Justice Coney Barrett who really focused on this question and was quite troubled by. I mean, she taught civil procedure in law school, so the idea of what she understands what the complexity of domicile is, but also all these different questions about parentage and other types of things. And she was clearly very troubled by the idea that you would be trying to apply some kind of parentage test or domicile test.
Yeah. Um, I seeing Daphne Kwok's question, which is better statutory or constitutional, I think we have an understanding of where you guys stand on that. I'm curious though, um, in listening to the Solicitor General, who, for those of you who don't follow this is the attorney for the government. This is the attorney for President Trump, who's standing for the executive order. Didn't really have much of a response, as I understand it from the lawyer's point of view. Didn't really have much of a response to Professor Mueller's brief. And I wonder if you would just play devil's advocate for a moment. Was there a better way to respond to what you guys are raising in this brief?
I mean, for one, I would have expected him to make the point that we're making about how this argument can't touch anything about the U.S. Constitution. As Rachel suggested earlier, that we're taking 20th century evidence and sort of projecting it backwards onto 1868, which is a kind of historical counterfactual in a way. I would have expected him at least to try to get the justices to take this example and kind of shift it away from having any constitutional impact, but he didn't. He didn't do that. I think that might have been one effective partial answer to the question. I don't know whether Rachel, John, whether if you were John Sauer and you were standing up there and my brief were thrown at you, what would you say?
I mean that's probably where the most effective place for him to have gone. I think he was a little bit caught between his arguments. So he had an argument on the 14th Amendment that said, hey, there was an original understanding of the 14th Amendment, which I think a lot of people disagree with his argument on that. There's original understanding of the 14th Amendment that was more limited, and it got expanded by the Roosevelt administration and from 1939 on. But then that sits right up against his argument on the statute. But he says, but ignore the new understanding that existed in 1940 when they passed the law, and only interpret the statute according to the what I say is the pre-1940 understanding. So I think he was a little bit in a box with that.
Yeah, I think the best way to articulate the government's position to make sense of how any of this can fit together coherently is to say that to go to what John was saying, the original meaning of the 14th Amendment isn't a carte blanche territorial birthright citizenship. It means something more limited than that. Congress used the exact same language that is in the Constitution And Congress at the time that they did that presumably meant to encompass exactly what the Constitution did, no more and no less. That's why they chose that exact same language. They echoed rather than modified. And when they repassed the statute in 1952, they did the exact same thing. They echoed rather than modified. And by not changing the statute over time, Congress was really just saying, yeah, we take what the 14th Amendment says, and then we're going to have these other rules about people in other situations. I think that's what the government is trying to say here. I'm not personally very convinced by that line of reasoning, but I think that that's the line that the government is taking in this case, and that's the delicate sort of dance that the Solicitor General was trying to dance at oral argument.
He was arguing here. I know we're over time, but I see that there's still a lot of interest, and we understand if you have to drop off, but a couple more interesting questions being posed here. A couple of them are sort of connected. My friend Malcolm Lee asking, how does the government explain the Supreme Court's failure to apply a domicile or total allegiance requirement in the years since Wong Kim Ark? Is that negligence? And in the same vein, another attendee asking, is the government in its ruling since Wong Kim Ark simply negligently ignoring the alleged domicile requirement? Would that pass constitutional muster?
Yeah, I think again, this goes to the tap dance that they're trying to walk, which is that if the 14th Amendment meant one particular thing in 1860, I'm going to get the
1868.
Thank you, 68. I was close, but I couldn't get that last digit in there. If it meant this one particular thing in 1868, it doesn't matter if people sort of fudge around the lines later in history. It had this one original meaning, and that has carried through history. And you can't change what the Constitution means by not enforcing it particularly well. Again, I think that's a really tough position to take given the facts of this case and the arguments that we presented to the court. But I think that would be the answer. Even if you're negligent, you can't change what the Constitution means.
I want to get
It's worth noting that we're at a moment, in I guess you'd say jurisprudential history, where this idea that the Constitution means exactly what it would have meant to a person walking past Independence Hall in 1789 or 1868 when it comes to the 14th Amendment, that idea, which is called originalism, is kind of at its apogee, right? Like it is coin of the realm on the
We're
current
there right
Supreme
now.
Court.
Yeah.
Somebody who is not committed to this idea that meaning gets fixed at the moment the ink dries, would be more open to the idea that unbroken practice for decades and decades of usage of that constitutional term can itself provide meaning of what that constitutional term means. That's something that a minority of the justices on the court today believe, but there are other times in the court's history when that idea, sometimes given the, I think, unfortunate term living constitutionalism, there have been times where the majority of the court has been more open to the idea that meaning is not fixed in time when the ink dries, but instead is a kind of ongoing product of a conversation about what the Constitution means across.
Don't they say a living document? I mean,
yeah.
So just one point on that. The wonky irony here is that the government was actually relying to some extent on the idea that the Constitution should be reinterpreted in light of things that weren't present or weren't really prominently present in 1868. There wasn't the same type of immigration restrictions. You didn't have the same types of people that we now look at as undocumented aliens in 1868. And they actually kind of pitched that to the court and Justice Alito was one of the people that I was pitched to. And it was partly what in some ways gave rise to Chief Justice Roberts' rejoinder saying he said, but it's the same Constitution. So it's definitely one of the tensions that was present in the argument.
This is actually a little tangential to what we've been talking about, but going to the Peruvian Japanese experience and how it might be reflected again in our environment today. Reverend Shinseki coming forward and asking, during World War II, the U.S. detained the Peruvian Japanese to be used as prisoner exchanges. In our present situation, could that be used, for example, with Iranian Americans or people of Iranian descent? Could there be a way to employ the same circumstance? Because that wasn't litigated. I think
Uh,
we stumped
I
them.
mean, the analogy would be that if there were Iranian nationals in another country in the Americas, um, and we were at war with Iran, and there were U.S. citizens or Americans trapped in Iran, whether the Peruvian Japanese precedent would provide a kind of floor on which to build a new prisoner, kidnapping and prisoner exchange program. Although the Peruvian Japanese story or the Japanese Peruvian story is sort of hidden in the shadows of the Japanese American story, I think there's a reasonable consensus that the government's actions in World War II vis-a-vis Japanese Peruvians were atrocious. And I think it would be difficult at this stage in history to point to that as a kind of positive example of the way in which the government should behave during a period of declared war. Having said that, we seem to be living in a time when all bets are off. So, I wouldn't, I'm with Rachel on this one. I would not want to be a betting person when it comes to a question like that, at least not in this environment.
Yeah.
And I think if you're looking at sort of these three cases and which one is the most troubling and potentially capable of repetition, it's got to be the enemy alien case, Larry's parents. My grandfather was also rounded up as an enemy alien and seized right after Pearl Harbor. And we're seeing that today. The Enemy Alien Act is being invoked again to seize people, and not with and the history then and the history now is not necessarily a proud one in terms of due process and evidence and all sorts of other things. A reasonable basis for the detention. I think my grandfather got seized because he was a community leader, notwithstanding the fact that he was in poor health.
It is those stories of those individuals, people like Larry, who come up and will stand before America and say, look at the history. Look what you did to people who just happened to look like me or happened to look in some way that wasn't for the majority's consumption and approval. Uh, these are and as Larry says, we'll stand for all of them, right? You have to be able to stand up and say,
Joe, if I could add just one word, I do want to make sure that we acknowledge the courage that it took for Larry to have his story be told to the United States Supreme Court. We've alluded to the risks that a certain interpretation of the Constitution could pose, this kind of retroactive stripping of citizens. It seems awfully unlikely. But one of the other families in the brief whose story I was given permission to tell, um, sort of had to have a family caucus about it before granting permission, because I think they were very, very reasonably concerned about sticking your head up in this environment. There is that old Japanese saying, the nail that sticks up is the one that gets hammered. And so, Larry, I just want to make sure that I have the chance directly to say to you that I recognize the courage that it took for you to to put your face and your
You
family's
know,
story on this
yeah, I
on this case.
appreciate that, Eric. I guess I'm too ignorant to acknowledge that, I could be the nail that sticks up. So, and my experience in my work, I'm not my day job, I guess. I'm uh, yeah, just I am the nail that sticks up. I have to be the one, and so it's maybe my experience is that this is what everyone needs to do. We need to uh, stand up and be counted. So, but I appreciate you mentioning that. Just I'm just honored to be part of this. The brief, and hopefully we're successful.
Yes.
And
All right, thank you.
Larry, I hope you are not failing to notice the number of people who are putting up plaudits
No,
and approvals for you and hearts
it's
for
all
what
my
you've done.
family that are doing that. So,
Don't think so. Don't think so. And to your
all right,
point
thank you.
that we do this for all, right? It
Hmm.
not only our own community, but for all. This is critically important at this time. Um, all of you, I want to thank you for being part of this conversation and for keeping the conversation alive and moving forward. Professor Muller at UNC Chapel Hill, John Nakahata and Rachel Grossman, thank you as well, and your firm, HWG, for standing up and taking this on. And of course, Larry Oda for
Oh,
telling your story, your family's story, and always for your advocacy for the community. Also, again, thanks to the sponsors of this program, the National Japanese American Memorial Foundation, the JACL, APIA Vote, and the Heart Mountain Foundation for all you do to keep this subject front and center for all of us. Thank you very much. And keep watching because we're only probably weeks away from a decision from the court on this. So let's keep an eye on that. Thank you all.
thank you, Joey.
Thank you.
Everyone,
Thank
thank
Thanks,
you.
you.
everyone.
Everybody.
All right,
Thank you.
bye-bye.